Dear students, subscribers and the viewers, welcome to the IAS Mentor. This would be our lecture number 24 in the series Indian Polity, and the objective of this particular series is to provide a comprehensive idea about the subject Indian Polity, and in the process we'll cover the Indian Constitution, and also we'll touch upon the important books like LAXMIKANTH, which is considered to be one of the most important book for the preparation of the students preparing for the civil service examination. But as I already said, that this series is not only useful to the students preparing for UPSC IAS examination, but it will also be useful for the students preparing for other competitive examinations, especially the state public service examination where Indian polity is an important subject. Alright, so we are right now in lecture number 24. And we are in the process of understanding the fundamental rights. So already last couple of lectures I have dealt about certain important topics in fundamental rights. In fact, we have tried to understand some of the essential features of the fundamental rights, and then we have tried to understand as to what is Article 12 of the Constitution, which basically defines as to what is a state. So we have seen that as well. And that definition of state is only for the purpose of part 3 of the Constitution. We have understood that also. And anything that falls within the definition of state, and in case if their actions are violative of the fundamental rights, then the affected individuals can approach the courts and get it enforced in a court of law. For that purpose, first we'll have to define the term state, which is basically done under Article 12. And then we also seen Article 13 of the Constitution, where Article 13 of the Constitution gives primacy to the fundamental rights. And how does it give primacy to the fundamental rights? It does give primacy to the fundamental rights by saying that if any law is in violation of the fundamental rights, such law can be declared to be invalid. And for which Article 13 also defines as to what is a law. So law includes the law made by the parliament and the state legislature. Law includes the ordinance issued by the president and the governors. Law includes rules which is made in the form of delegated legislation or any other non-legislative sources of law like customs and all those things, they also fall within the definition of law. So if any of these things are violative of the fundamental rights, these things can be declared to be invalid. But however, the question is whether a constitutional amendment will fall within the definition of law. Article 13 of the Constitution was amended by the 24th Constitutional Amendment Act in 1971, wherein it clearly says a constitutional amendment would not be considered to be law under Article 13. And hence a constitutional amendment can be used to take away any of the fundamental rights. So this also we have understood. And then if you see the last lecture, we also understood as to what is Article 14. Article 14 says the state shall not discriminate against any person with regard to what is called as equality before law or equal protection of laws. So we also understood as to what is the concept of equality before law, which is more a formal equality, which says that the principles of the state or the law which is made by the state shall not discriminate between the citizens, or it is basically coming with an idea of formal equality or the supremacy of the law. Whereas the concept of equal protection of law is not just coming with a concept of formal equality, but it is more of substantive equality. It says that everybody shall be given an equal opportunity to rise in their life. Everybody shall be given an equal opportunity to achieve whatever they want to achieve. So in the process, in order to provide equal opportunities, there may be a discrimination. If at all it has to be done, it can be done by the state. But the discrimination should be largely positive in nature. That is, it should be a positive discrimination. And for that purpose, the state can also make what is called as a reasonable classification. So I am just telling the crux of what I have discussed, but I have elaborately discussed this in the previous lecture. So if you want to know more about Article 14 of the Constitution and to understand the concept of what is equality before law and equal protection of laws, please do refer to my lecture number 23, where I have completely explained almost this particular article for the entire lecture and with relevant examples. Now with that, we will move to the next article under the theme right to equality. The theme right to equality contains in fact 5 articles, Article 14, 15, 16, 17 and 18. So we already understood Article 14, which talks about equality before law, and the equal protection of laws. So now we are going into Article 15 of the Constitution, where again the major theme is revolving around what is called as the principle of equality, or in other words, no discrimination. While Article 14 in general is talking about the state in its policies or in its principles should not discriminate, whereas Article 15 is making it very clear that the state in its policies shall not restrict or shall not discriminate with regard to certain areas. So what are the areas it shall not discriminate? But in other areas, if at all it want to discriminate, it can discriminate. But with regard to certain areas, it shall not discriminate. So what are the areas in which it shall not discriminate is what we are going to understand here. So the general principle under Article 15 is that there shall be no discrimination by the state. So looking to Article 15 here. So Article 15, the general idea is prohibition of discrimination. So this word is very important. Prohibition of discrimination on the grounds of religion. It's based on the religion that you believe in, what you profess and practice. Race is based on basically the physical characteristics of an individual. There are different races in our country. So for example, we have Dravidian race, we have Aryan race, we have Mongoloids. And India is a country of lot of races. So no discrimination by the state on the grounds of race or on the basis of caste. We have a caste system that is there in our country. So depending upon caste with which anyone belongs to, that shall not be the basis of discrimination, or on the basis of sex, which is biological in nature, or on the basis of what is called as place of birth. So wherever you are born in the territory of India, that shall not be the ground for the discrimination of the individual. So this is basically what you understand the general principle under Article 15. So basically under Article 15, the state shall not discriminate on these grounds. But if you see further, it is elaborated by number of subclauses. So let us assume if Article 15 is the rule, and under that Article 15 there are number of sub-rules which further explain the main idea which is governed under Article 15 of the Constitution. So we'll try to understand that one by one as to what are the various sub-rules or clauses under Article 15 of the Constitution. So first thing is Article 15 clause 1. So what does Article 15 clause 1 of the Constitution is saying? The state shall not discriminate against any citizen, because whenever you read the fundamental rights, there are certain keywords that you'll have to take into account, and these keywords are very, very important for you to understand as to what that exactly that particular right is. Is that right is only against the state? Is that right is only to the citizens? You will get that understanding only when you read all these keywords. So what is Article 15 clause 1 is saying? Article 15 clause 1 is saying the state shall not discriminate any citizens on the grounds only of religion, race, caste, sex or place of birth or any of them. That means Article 15 clause 1 is basically a right only against what? Only against the state. The state shall not discriminate. It is not a right against a private individual or a private entity, because the right is basically against whom? The right is basically against what is called as a state. The state shall not discriminate against its citizen. That is what is very important. So who can exercise and enjoy these rights? The right shall be exercised only by the citizens. If it is available to any of the others apart from the citizens, then they have to use the word what is called as person. But by choosing the word citizen, the Constituent Assembly specifically confers this right upon who is called as only the citizens, and not to any of the other categories of people apart from the citizens. That means, can the aliens in India exercise right under Article 15? Not possible. It is only available for the citizens. In fact, not only Article 15, which I have already discussed, it is Article 15, Article 16, Article 19, Article 29 and Article 30. So these 5 fundamental rights in Part 3 of the Constitution are exclusively reserved only for the citizens, while all the other rights is available to the citizens as well as the aliens, but these 5 rights are available only to the citizens. So therefore Article 15 is only to the citizen, and Article 15 can be enforced only against the state. That means who is the actor, and if they do something which can be considered to be violative of the fundamental rights under Article 15, it has to be done only by the state, not by any private authorities. What falls within the definition of state, for which we have understood already Article 12 of the Constitution. For those students who are directly listening to this particular lecture, I would recommend you to go and see as to what is the explanation of state under Article 12. and then probably you will have a broader understanding of whatever we are discussing right now. All right. So the state shall not discriminate against any of its citizens, and on what are the grounds they shall not discriminate? They shall not discriminate either on the grounds of religion, race, caste, sex, place of birth, or any of them. So the state shall not discriminate in its policies. So what shall not be done by the state? The state shall not discriminate in its policies. The state shall not discriminate in terms of law it makes. The state shall not discriminate in terms of any of the action that it performs. It shall not discriminate any of the citizens on the grounds of what? It shall not be solely on the grounds of religion or on the grounds of caste, race, sex, or place of birth, or a combination of any of these things or any of them, which is not to be done by the state. If the state is doing that, then it is basically a violation of the fundamental right under Article 15 Clause 1. Say for example, let us assume the state is coming out with a policy. You know what is a state? The state can be government of India or government of any of the states. State government. It can be Parliament of India or the state legislature. It can be any local authorities. It can be, apart from that, any other authority within the territory of India, depending upon the various parameters we know as to when they will fall within the definition of state. So anything that falls within the definition of state, if they come out with a policy, suppose let us assume tomorrow there is a policy which is made by the state, where it is saying that it will allow only people from specific caste to get the benefits of the government schemes, and people in the other caste will not be eligible to get the benefit of the government schemes, then that is a discrimination on the basis of caste, which the state should not do. So that's basically what you'll have to understand under Article 15 of the Constitution, especially under Article 15 Clause 1. So under Article 15 Clause 1, what is the basic understanding you should have? The state in its policies shall not discriminate people, that is its citizens, on these grounds. Only on these grounds. That is what is very important. Can the state discriminate on any of the other grounds which is not mentioned there? Suppose, can the state discriminate, say let us assume on the grounds of language, because language is not explicitly mentioned here. Is it possible for the state to discriminate on the grounds of language? That is very much possible, because it is not mentioned here. Can the state discriminate on the grounds of residence? That is very much possible. That is not given under Article 15 of the Constitution. Say for example, today if you take a lot of educational institutions in a particular state, those educational institutions in a particular state do reserve some element of seats for the people in the local residence. So is that possible for them to reserve seats for the people in the local residence? So residence is different, place of birth is different. So they are doing it on the basis of residence. Residence means these are people who have stayed there for some period of time. So can it be done on the grounds of residence? Can seat be reserved in the educational institutions? That is possible, because the residence is not explicitly mentioned here. But whatever is explicitly mentioned here, that is not a ground for discrimination, or the state in its policies or laws should not discriminate them. So that is basically what you'll have to understand. I'm sure that Article 15 Clause 1 is very clear, but under Article 15 of the Constitution, there are a lot of other clauses. Unless and until we understand the other clauses, our understanding of Article 15 will not be very complete. So let us move to Article 15 Clause 2. So what is Article 15 Clause 2? Article 15 Clause 2 is again a sub-rule under Article 15, which is an extension of the major theme under Article 15. What is a major theme under Article 15? The major theme under Article 15 is that the state shall not discriminate between its people. That is, the state shall not discriminate among its citizens on the grounds of religion, race, caste, sex, place of birth, or any of them. So this is basically Article 15 says. While Article 15 Clause 1 says that the state shall not discriminate in its policies or in its laws against the citizens. Whereas what is Article 15 Clause 2? Article 15 Clause 2 is saying it is not necessarily the state, neither the state nor the private individuals. So because here the word state is not explicitly mentioned, so no citizen shall be subjected. So that is what is important. So while both in Article 15 Clause 1 and Article 15 Clause 2, who are entitled to this fundamental right is only the citizens. But whereas under Article 15 Clause 1, it is only the state which shall not discriminate. But whereas under Article 15 Clause 2, neither the state nor or any private authorities or individuals, private individuals or authorities. So both of them. So neither the state nor the private individual shall discriminate people on the grounds of religion, race, caste, sex, place of birth, or any of them. Or these shall not be the grounds on which the citizen shall be subjected to any form of disability or any form of liability or any form of social discrimination, especially that these factors that I told, that is religion, race, caste, sex, place of birth, or any of them, should not be a ground on which people are discriminated from having access to certain public places like parks or places of mass resort, like public entertainment areas, or places of worship, or roads, or any of the other public places which is either completely under the control of the government or partially funded by the government. It is not talking about any private place, or it is not talking about any private property, but those property which are public in nature, or those property where the government is spending to maintain that particular property. In those areas, they shall not be restricted from entering or having access to any of the services on the grounds of religion, race, caste, sex, places of birth. So this is basically what you understand by Article 15 Clause 2. While Article 15 Clause 1 is talking about no discrimination, Article 15 Clause 2 is also talking about no discrimination. But whereas Article 15 Clause 1 is conferring the right upon the citizens only against the state, whereas Article 15 Clause 2 is conferring the right upon the citizens both against the state as well as the private individuals. So nobody shall bring in any form of discrimination or disability or social liability with regard to access to certain public places as mentioned in this particular article. So that is what is Article 15 Clause 2. And further, if you see Article 15 Clause 1, Article 15 Clause 1 is talking about the broader laws and policies made by the state, whereas Article 15 Clause 2 is only talking about a specific action where people are restricted from having access to certain places of mass resort, where people are restricted from having access to entry into certain places of worship or public roads or public tanks. So it is restricting itself to specific actions, while Article 15 Clause 2 is much broader in its ambit. But the basic difference is, while Article 15 Clause 1 is both against Article 15 Clause 1 is only against the state, whereas Article 15 Clause 2 is both against the state as well as the private individuals. But if you see in essence both these articles, that is Article 15 Clause 1 as well as Article 15 Clause 2, in essence they based on the principle of what is called as no discrimination. When I talk of no discrimination, in essence they are based on the principle of what is called as equality before law. That means everybody shall be treated equally in the eye of the law. So that's basically the idea. So Article 15 Clause 1 and Article 15 Clause 2, they are based on the principle of what? Article 15 Clause 1 and Article 15 Clause 2. I am repeating it again. So both are based on the principle of what is called as equality before law. So whenever I talk about equality before law, it is based on the idea of what is called as no discrimination. But however, if you have observed my lecture under Article 14 of the Constitution, Article 14 is not only talking about what is called as equality before law, it also talks about what is called as equal protection of laws. So the idea of both equality before law as well as equal protection of laws is reflected in Article 15 as well. While Article 15 Clause 1 and Article 15 Clause 2 is based on the principle of equality before law, but Article 15 Clause other rules as well, other clauses as well, that is Article 15 Clause 3, it has got Article 15 Clause 4 and it has got Article 15 Clause 5. We'll try to understand as to what they say, Article 15 Clause 5, and there is also what is called as Article 15 Clause 6. So if you look into the provisions of these four subclauses under Article 15, they are all based on the principle of what is called as equal protection of laws. So there is a difference between as to what is equality before law and what is equal protection of laws. So let us try to understand as we will move further as to what Article 15 Clause 3, 4, 5 and 6 discuss, and that is very important. So let us move forward, let us try to understand all those things. Okay. So please come here, we will proceed further to Article 15 Clause 3. I am sure that you have understood as to what is Article 15 Clause 1 and Article 15 Clause 2. Both are basically having an idea of what is called as equality before law, that is no discrimination. While Article 15 Class 1 is only against the state, whereas Article 15 Class 2 in its restricted domain, that nobody shall be discriminated in having access to certain public places. That discrimination should not be done on the grounds that you have discussed, neither by the state nor by the private individuals. So that is basically Article 15 Clause 2. But both rely or rest upon the principle of equality before law. But that is not the end of the story when it comes to Article 15. Article 15 also talks about what is called as equal protection of laws. Or in other words, it also carry forward the principle of equal protection of laws under Article 15 Clause 3, 4, 5 and 6. So let us now try to understand all these clauses. What is this Article 15 Clause 3? If you read Article 15 Clause 3, Article 15 Clause 3 confers certain special powers upon the state for making special provisions for the empowerment of women and children. That is what is very important. So it confers special powers upon whom? The state, for making special provisions for the empowerment of women and children. So to understand this, first you'll have to understand that while Article 15 Clause 1 and Article 15 Clause 2, which confers fundamental rights upon the citizens, whereas Article 15 Clause 3 does not confer any fundamental right upon the citizen. It only confers what? It only confers or it only provides certain powers upon the state. So look into the words. It confers powers upon the state. It is not providing any right upon the people. Or in other words, we can say Article 15 Clause 3 is an enabling provision in the Constitution, or it is an enabling provision in the Part 3 of the Constitution. So what do I say, or what do I mean by an enabling provision? Enabling provisions are there in Part 3 of the Constitution, which does not confer any right upon the people. Rather, it confers certain element of power upon the state. And by using this enabling provision, or by using this power, the state can take certain special measures. So thereby it can empower certain categories of people in our country. And that's basically what you'll have to understand. So if you look into Article 15 Clause 3 very carefully, it is saying that it confers powers upon the state to make special provisions to empower women and children. That means the Constitution under Article 15 Clause 3 is conferring powers upon the state. So state, we do understand what is a state from Article 12 of the Constitution. It can be the state government, it can be the union government, it can be the local authorities, it can be the parliament or the state legislature, whatever it is. All those things that will fall within the definition of state are empowered under Article 15 Clause 3. Article 15 Clause 3 is conferring powers upon the state to take any action, and by that action, if they want to confer certain special privileges or certain special entitlements upon women and children, they can do it. So that is basically what is called as Article 15 Clause 3. That means, to take one example, Article 15 Clause 3 is giving power to the parliament, let us assume, to make a law that would empower women, to make a law that would empower children, to make a law that would treat women separately than that of men. So try to understand Article 15 Clause 3 is not based on the principle of equality before law. It is not talking about no discrimination. It is talking about equal protection of laws. Equal protection of laws allows for what is called as positive discrimination, but provided that people are coming under different groups or people are reasonably classified. So here, the idea of the Constituent Assembly to have this Article 15 Clause 3, for them women and children are a reasonable classification. So women and children are not equally placed with that of, say, let us assume men. And men is considered to be more dominant probably in the society, whereas women and children are part of vulnerable sections of the society. So in order to give them an equal footing, in order to help them also to grow and develop, if at all the state wants, the state can make some law or come out with certain policies that can empower women and children. So that is basically what is the provision of Article 15 Clause 3. So Article 15 Clause 3 does not confer any right upon women and children. Article 15 Clause 3 is only empowering the state to take measures, and by that measure they can provide certain privileges to women and children. So if the state comes out with certain measures, then women and children can exercise and enjoy those privileges. But women and children do not directly derive any powers and privileges from Article 15 Class 3, because Article 15 Class 3 is conferring this power only upon what is called as the state. So, this is the basic understanding you should have. So, accordingly, under Article 15 Class 3, you will understand a number of steps has been taken by what is called as a state. Say, for example, one example that I can give is the 73rd Constitutional Amendment Act, which gave constitutional status to the Panchayat and the municipalities in our country today. The 73rd Constitutional Amendment Act, which gave the constitutional status to the Panchayat and municipality, also brought in what is called as 1/3 reservation. Minimum 33% reservation for women. So when this minimum 33% reservation was brought in for the women, it was challenged in the court that while giving reservation to women and not to the men, which means it is a principle of it's discriminating, it is a discriminatory principle, and hence it is violative of the rights in the constitution, because Article 14 talks about equality before law and Article 15 Clause 1 talks about no discrimination by the state on the grounds of religion, race, caste, sex and place of birth. So it was argued that it is a discrimination on the ground of sex because you are giving reservation only to the women. Whereas the court said that Article 15 Clause 1 should also be read along with what is called as Article 15 Clause 3. Well, Article 15 Clause 1 is a general principle. We understand that it talks about no discrimination. But if you read Article 15 Clause 3, it also confers powers upon the state to make special provisions for the empowerment of women and children. So, by using Article 15 Clause 3, if the state wanted to confer some special privileges upon women and children, they can do that. And hence, it is coming under the principle of what is called as equal protection of laws. Or in other words, only the equals are to be treated equally. Here, the men and women are not equally placed in the society. Because of our cultural factors and all those things, women to win the election is not easy. Women to come out of all the social issues that they have got and to contest election equal to that of men and to win the elections, they are not on equal footing. And hence, they are all two different groups. And because they are all two different groups, different laws may apply to them, because the equal protection of law only talks about that the equal shall be treated equally, and hence to that extent this was upheld by the Supreme Court. If you want more examples, I am quite sure that most of you are aware of what is called as an odd even policy that the Delhi government has brought in. So this odd even policy was brought in by the Delhi government, in fact to minimize pollution in Delhi. So whenever during the Diwali time, when the pollution level increases, few years back the Delhi government has brought in this odd even policy, and the idea behind this odd even policy is to regulate the movement of especially the four-wheelers, the cars, so that they can reduce the vehicular pollution. And the concept is on an odd dated day, that is days like number 1, that is 1, 2, 3, so sorry 1, 3, 5, on odd dated dates, only a car with a registration number having odd numbers are allowed to move in the city. And on an even dated dates, only cars registration number ending with what is called as a even number, they are allowed to ply in the city. So this is basically this odd even policy. So in this way, they thought that it can have some kind of effect in reducing the pollution in the city. But however, even under this policy, if a woman is riding a vehicle, a car, then she is exempted. If she is riding a vehicle alone, she is exempted. If she is allowing a vehicle with a child less than 12 years of age, she is exempted. So the odd even principle or the odd even policy does not apply to a woman. So this is again might seem to be discriminatory, but it is a positive discrimination. The state is empowering the women under the provisions of what is called as Article 15 Clause 3. And to give you a very simple example, today a number of state governments are giving a free ride to women in the bus. So most of you might be aware of it. I think this is followed in number of state governments. Now that again the state can do that because the state is empowered to make special provisions for women and children. So this is all coming under the concept of what is called as equal protection of laws, not under the concept of equality before law. Alright. And for children, is there any special privilege? Yes. There is an act which is called as the Juvenile Justice Act. You might have heard about what is called as a Juvenile Act. If you see this Juvenile Act, So juvenile is any child who is less than 18 years of age, so who is not yet an adult. So if a child comes in conflict with law and if they have committed any crime or offense, then they are all tried under as per the provisions of what is called as a Juvenile Justice Act. If you see a Juvenile Justice Act, if a child commits an offense, the child is not to be treated as an adult, or the child is not entitled to the same punishment that would be given to an adult. They are all treated separately, they are all treated differently. And the punishment for a child which will be much lesser, and a child is usually sent to a correctional home if a child has committed any offense. So the law is different in these cases because the child is to be treated separately or differently, because the mental abilities of the child is not similar to that of an adult individual. And to that extent, try to understand. So these are all some laws or policies which is brought in by the state to differentiate between what is called as the women and children among with the other categories of people, because women and children are considered to be what is called as a reasonable group. But one thing that you have to keep in your mind, the most important thing that you have to keep in your mind is that the women and children, so this is what is very important, they cannot exercise this as a right under the constitution. It is only a special privilege which may be conferred upon by the state upon the women and children, because the constitution is only empowering the state, and by using this power, if the state makes a law or a policy, then it can be exercised by women and children. So in general, if you see Article 15 Clause 1 and Article 15 Clause 2 is based on the principle of equality before law, whereas Article 15 Clause 3 is based on the principle of what is called as equal protection of laws. So we have other provisions also, we have other rules also, articles also, which is again based on the principle of what is called as equal protection of laws, and one such another article is Article 15 Clause 4. So we'll move to next article, Article 15 Clause 4. And this is again based on the principle of what? Equal protection of laws. Wherever I say that it is based on the principle of equal protection of laws, it does not follow the principle of equality before law. It provides for what is called as positive discrimination. It provides for discrimination, it provides for affirmative action, but it is a positive discrimination. And one such article is also what is Article 15 Clause 4. In fact, this Article 15 Clause 4 was not part of the original constitution. I'll come to what is Article 15 Clause 4. But before come to that, you should also know this Article 15 Clause 4 was not part of the original constitution. And when was this Article 15 Clause 4 was inserted into the constitution? Article 15 Clause 4 was inserted into the constitution by the first Constitutional Amendment Act in 1951. That means after the constitution came into force, for the first time the constitution was amended, and through that amendment Article 15 Clause 4 was inserted. And what was the need for this Article 15 Clause 4? So let us go a little to understand the background behind as to why this amendment was needed in the first place. At that point of time in 1950 in the state of Madras, so you understand at that point of time there was no state of Tamil Nadu, it was state of Madras. In fact, even Andhra Pradesh was not there. It was one single state, that is state of Madras. The state of Madras came out with a policy. And what was the policy of state of Madras? The state of Madras was trying to reserve some seats in their educational institutions. They are trying to reserve some seats in their professional colleges and in certain other educational institutions, especially for the people from the backward community and for the people belonging to the scheduled caste and scheduled tribe. They are trying to give some reservation to the backward community and the historically exploited communities like the scheduled caste and scheduled tribe in the educational institutions. And this policy of state of Madras was challenged in the Supreme Court, and that case came to be what is called as a Champakam Dorairajan case. And thereby this case came to be what is called as Champakam Dorairajan versus State of Madras case. Now in this case, the court has to decide whether the policy of reservation is allowed or not. And the people who argued that the reservation should not be allowed, they are of the argument if reservation is given, then it violates the principle of equality. And Article 14 clearly says that the state in its policy shall follow what is called as equality before law. Or in other words, the state shall not deny any person equality before law, which means everybody shall be treated equally in the eye of the law or in the policies of the state. So it would be violation of the principle of equality. Not only it is violation of the principle of equality, it shall also be violation of what is called as Article 15 of the Constitution. To be very specific, Article 15 Clause 1. So if you go to Article 15 Clause 1, you will understand. Article 15 Clause 1 says that the state shall not discriminate against any of its citizens on the grounds of religion, race, caste. So here the reservation was basically given on the basis of caste, and hence this was also considered to be violative of Article 15 Clause 1. And it was argued that this reservation policy should be struck down. And the court was convinced with this particular argument, and the court has struck down this reservation that was given by the state of Madras in the educational institutions to the backward classes and to the scheduled caste and scheduled tribe. The basic argument that the court has given is that this policy of reservation, if you are giving it on the basis of caste, it is violative of the principle of equality, and to be very specific, Article 15 Clause 1. And there is also no enabling provision in the Constitution that enables the state to take this affirmative action, or there is no enabling provision in the Constitution that would allow you to confer these privileges upon the backward people. See, there is Article 15 Clause 3, which enables the state to provide special provisions for the women and children. So similarly, there is no enabling provision in the Constitution that enables the state to come out with a policy, and that by that policy to confer special privileges upon women and children. So in the absence of specific enabling provision in the Constitution, if you do that, then that actions of the state shall be considered to be violative of the principle of equality. And to that extent, this reservation policy was struck down by the courts. And after that, the parliament thought, okay, if that is your problem, so what we will do, we will create this enabling provision. We will amend the Constitution and we will create an enabling provision in the Constitution, and then it would be constitutionally valid for us to provide steps that would give reservation to the backward classes and the scheduled caste and scheduled tribe. So in fact, this Article 15 Clause 4, which was brought in by the first Constitutional Amendment Act, was exactly in response to what is called as the Champakam Dorairajan case. So after the Champakam Dorairajan case, the Parliament amended the Constitution and they inserted what is called as Article 15 Clause 4. So now with this background knowledge, if you read Article 15 Clause 4, you will understand. It confers powers upon the state to make special provisions for the advancement of the socially and educationally backward classes and the scheduled caste and the scheduled tribe. So as per the Constitution, it is for the President of India to come out with a list of scheduled caste and scheduled tribe. And similarly, the President can also come out with a list of the backward classes. And there's a lot of other provisions for which we'll have to understand the lot of provisions in the Constitution, which I'll do it later. But anybody who is considered to be backward classes or the scheduled caste and scheduled tribe, they can be conferred certain privileges. And who can provide that privilege? The state can confer this privilege. So this was brought in response to what is called as the Champakam Dorairajan case. So now this acted as an enabling provision. This Article 15 Clause 4 acted as an enabling provision for the state to provide for what is called as reservation in educational institutions. So basically, today a lot of reservation is given in educational institutions. So that reservation in educational institutions that is given to the backward classes and to the scheduled caste and scheduled tribe. So that is basically done by the state based on the provisions of what is called as Article 15 Clause 4. So this is the basic understanding you should have. Is that clear to all of you? So now the Constitution was further amended. It did not stop here. The Constitution was further amended, and there was also one more article that was inserted into Article 15 Clause 5. One more article was also inserted into Article 15, and that is nothing but Article 15 Clause 5. So many students might wonder what was the need for this Article 15 Clause 5. Because Article 15 Clause 4 already allowed the state to come out with an enabling provision. And through that enabling provision, they were able to give reservation to the backward community, that is the social and educationally backward classes and the scheduled caste and the scheduled tribe in the educational institutions. Now, under such a situation, what was the need to make another constitutional amendment? So let us try to understand and let us try to understand in the history what was the need for this Article 15 Clause 5. So if you see what is the need for this Article 15 Clause 5, Article 15 Clause 5 was inserted into the Constitution by the 93rd Constitutional Amendment Act. And in the year 2005, in response to what is called as a judgment which is given by the Supreme Court in Inamdar case. So you'll have to understand as to what is this Inamdar case. The first Constitutional Amendment Act inserted Article 15 Clause 4. And by the Article 15 Clause 4, there was an enabling provision. And that enabling provision allowed the state to make reservations in the educational institutions for the benefit of socially and educationally backward classes and the scheduled caste and the scheduled tribe. So this enabling provision was used by the state to further give reservation in the private educational institutions. So initially they started giving reservation only in the educational institutions run by the state. And then subsequently they expanded the scope of reservation in what is called as private educational institutions. So when the scope of reservation was extended to the private educational institutions, this was challenged in the Supreme Court. And that came to be what is called as the Inamdar case. But the Inamdar case made it very clear, whatever is the enabling provision that is under Article 15 Clause 4, Article 15 Clause 4 allows the state to give reservation in the educational institutions run by the state, but not in the educational institutions which is run by a private authority or by a private entity. So while reservation in the government education institution is all right, but you cannot expand the scope of reservation to the private educational institutions because there is no such enabling provision in the Constitution. And because you are not allowed to do that by the Constitution, and hence expanding the scope of reservation to the private educational institution is unconstitutional. This is what the Supreme Court has told in the Inamdar case. Now in response to this Inamdar case, then the Parliament thought, because there is no enabling provision in the Constitution, you are telling us that we cannot extend it to the private educational institution. So we'll amend the Constitution and then we'll create the enabling provision for that also. And so they again amended the Constitution and they inserted what is called as the Article 15 Clause 5 by the 93rd Constitutional Amendment Act in the year 2005. And then they also specifically put in the word what is called as private educational institution. That is what is very important. That means by inserting the word private educational institution, now the reservation can also be extended to what is called as private educational institutions. So that is basically what you'll have to understand. So today the enabling provisions of the state allows them to make a law, and then if they want to extend the reservation, they can extend it even to the private educational institutions. So the central government, if they wanted to extend the reservation to all the central universities, including say let us assume many of the private educational institutions are there, then the Parliament can make a law and thereby they can extend the scope of the reservation to all the central universities by the law made by the Parliament. And if any of the state government wanted to extend the reservation principles to any of the state-run institutions, then the state legislature can make a law and they can extend it to various state-run educational institutions, be it even a private educational institution. So this is basically what you'll have to understand. So accordingly, one such central law that was made by the Parliament is what is called as the Central Educational Institutions Reservation and Admission Act, extending the principle of reservation to various central universities. So now it can also be extended to what is called as private educational institutions. If the state want to do that, they can extend it. Similarly, if any of the state government wanted to do that, they can also extend it to the private educational institutions, for which the state legislature has to make a law. Because education is an item in the concurrent list. So both the Parliament and the state legislature can make a law in this particular regard. So this is basically what you'll have to understand. But to put it a very simple way, the main objective behind Article 15 Clause 5 is to extend or to provide an enabling provision to extend the scope of reservation even in what is called as a private educational institutions. So this is basically what you'll have to understand. Is that clear to all of you? Now, if that is clear, then what is another development that has happened is that when the educational institutions started giving reservation, initially it started only in the government educational institutions. Then subsequently it was extended from the government educational institutions even to private educational institutions. Now while all these were okay, and these reservations was challenged in the Supreme Court in a case which is called as the Ashok Kumar Thakur case. So here it is not that the reservation should be stopped, but while giving reservation to the backward classes of people in the educational institutions, the Supreme Court in this particular case said that while you give reservation to the backward community in the educational institutions, be it the government educational institutions or be it a private educational institutions, the reservation should be restricted only to the non-creamy layer among the backward classes. Among the other backward classes, who shall get the benefit of reservation? Only the non-creamy layer and not the creamy layer. So to understand this completely, because we have not yet dealt with what is this creamy and non-creamy layer, to understand this, we'll have to go into what is called as the Indira Sahni case, which happened in 1992. But right now, I am not dealing with the Indira Sahni case because I am going to deal with that elaborately in the next lecture. When I take up Article 16 of the Constitution, that is equality of opportunity in matters of public employment, I am going to deal with that elaborately. But for time being, you remember that what was held by the Ashok Kumar Thakur case is that while you give reservation to the private educational institutions or the government educational institutions, that is all right. But however, when you give reservation to the backward classes in any of these educational institutions, who shall get the benefit of reservation among the backward classes? Only the creamy layer, only the non-creamy layer, and the creamy layer among the backward classes should be excluded from the benefit of reservation. So this is the law of the land even today. So this principle was accepted and this continues to be the law of the land. But the amendment to Article 15 did not end there, and the latest amendment that has happened to Article 15 is what is called as Article 15 Clause 6. And this Article 15 Clause 6 was inserted into Article 15 by the 103rd Constitutional Amendment Act in the year 2019, which provided for what is called as economically weaker sections reservation. I'm sure that most of you might have heard about the economically weaker sections reservation. So the economically weaker sections reservations was allowed by virtue of what is called as Article 15 Clause 6. So what is this Article 15 Clause 6? Article 15 Clause 6 is saying that in the educational institutions, be it the educational institutions run by the state, that is government educational institutions, or the private educational institutions. Now till this point of time, who are getting the benefit of reservation? One is the backward classes, that is the socially and educationally backward people. Socially and educationally backward people. Just focus on it for a few moments. Socially and educationally backward people. And then apart from that, people from these communities were also given the reservation, scheduled caste and the scheduled tribe. While the socially and educationally backward people, the scheduled caste, scheduled tribe, they are all getting the benefit of reservation under Article 15 Clause 4 and Article 15 Clause 5. Article 15 Clause 4 was giving reservation in educational institutions run by state. 15 Clause 5 extended that to even the private educational institutions. So whereas what is the intention of Article 15 Clause 6? In addition to these categories who are already getting the benefit of reservation, Article 15 Clause 6 inserted one more category, what is called as EWS reservation. They are economically weaker sections. So economically weaker sections, not necessarily that they are socially and educationally backward, not necessarily they are backward community, not necessarily they are scheduled caste or scheduled tribe by their caste. They may be from advanced caste also, they may be from the forward caste also, but these are categories of people even from the forward caste, but they are economically weaker. When I say they are economically weaker, that means their economic position is not good, that means their income is not up to the mark, and hence they are also deprived from getting education, and hence they should also be given certain privileges. And to give those privileges, first you need to have what is called as an enabling provision that enables the Constitution to provide special provisions for the welfare of the economically weaker sections. So in order to provide reservation to the economically weaker sections, up to 10% in educational institutions, be it public or in private educational institutions, Article 15 Clause 6 was inserted as an enabling provision in the Constitution by the 103rd Constitutional Amendment Act in 2016. And by inserting this 103rd Constitutional Amendment Act in 2016 and by inserting Article 15 Clause 6, today the state can provide reservation in the educational institutions apart from the socially and educationally backward people, that is the other backward caste, the scheduled caste, the scheduled tribe. The economically weaker sections can also get reservation up to 10%. And for which the government also gives certain criteria as to who would be considered to be an economically weaker section. So these criteria may not be very important for your examination, but you may have some knowledge, or you can have some knowledge about this also. So for example, any family, if their income is less than 8 lakhs, although they are from the general category, but their income is less than 8 lakhs, the entire family income, and if the income is less than 8 lakhs, that is not the only condition, then their property should be seen, whether they have any agricultural land 5 acres or more, and if that is also less, whether they own a house which is less than 1000 square feet, whether they own any plot, if it is a recognized municipality, if it is an urban area, it should be less than 100 yards, or if it is a rural area, it should be less than 200 yards. So both their income will be seen, their property will be seen. So when all these are checked, and if they're not eliminated under any of these category, that means they do not have any of these things and they are qualified under all these criteria. So in that particular case, although they may belong to the general community, still they are entitled to get what is called as the benefit of reservation under the category of what is called as EWS reservation, that is economically weaker sections reservation. So this is basically what you'll have to understand under Article 15 Clause 6. In fact, this Article 15 Clause 6 was inserted by the 103rd Constitutional Amendment Act in 2019. In fact, this 103rd Constitutional Amendment Act has not only inserted Article 15 Clause 6, it also inserted Article 16 Clause 6 by the same amendment in Article 16. I'll discuss that when I take up Article 16. And after this amendment was brought in, this amendment was challenged in the Supreme Court. And recently, the Supreme Court, before a couple of years, has upheld the validity of this constitutional amendment. I'll also discuss as to why this was challenged in the Supreme Court and what is the ground on which it was challenged and what was the reason as to why it was upheld by the Supreme Court. I'll discuss all those things when I take up Article 16 of the Constitution. For time being, this is the basic understanding you should have with regard to Article 15. So I'm quite sure that you are very clear about all these articles, especially Article 15. So overall, if you see Article 15 and the rules or the clauses under Article 15 can be classified into two. On the one hand, some of them follow the principle of equality before law. On the other hand, others follow the principle of what is called as equal protection of laws. Equality before law is there in Article 15 Clause 1 and Article 15 Clause 2. It is based on the principle of no discrimination. Whereas Article 15 Clause 3, 4, 5 and 6, they are all enabling provisions. They are all based on the principle of what is called as equal protection of laws. That is, the equal shall be treated equally. And therefore, the state can come out and make a reasonable classification and confer certain privileges upon the people. Article 15 Clause 3 is only for women and children. Article 15 Clause 4 is for the social and educationally backward people and the scheduled caste and scheduled tribe, where for them reservation can be given in the educational institutions run by the state. Article 15 Clause 5, the enabling provisions can be done for the social and educationally backward people, scheduled caste and scheduled tribe, but the reservation can also be extended in private educational institutions. Article 15 Clause 6, reservation can be given in the educational institutions for people belonging to the economically weaker sections. They are not people backward in terms of their caste. They are people advanced in terms of their caste, but they are economically weaker. Their economic situations and conditions are not right. And hence they are also eligible to get reservation up to 10%. And that is what you'll have to understand. So with that, we are coming to the end of Article 15. Very, very important article, and I'm quite sure that you'll have complete clarity once you have watched this particular lecture and understand as to what the Constitution talks about Article 15. In this way, in the next lecture, I'll also take up Article 16, and that is again a quite big article. So for the entire lecture, we'll discuss about Article 16 of the Constitution as well. So if you have any questions, you can reach out to me through my Instagram channel or through my Instagram account or through my Telegram channel, which is Babu_IAS_337. So otherwise, also you can reach out to me through the comments in the YouTube channel. And if you have any of your friends or family members preparing for the UPSC IAS examination or for any of the state service examination, you can recommend them watching these particular series, and of course the other quality contents that you are going to do in this particular channel. And I'm quite sure that it will be immensely useful to the students preparing for the competitive examinations. Thank you very much for watching this particular lecture. All the very best. Thank you.